All right, so continuing kind of our train of thought of looking at what are the limits on the civil liberties outlined in the Bill of Rights. We went through religion, and we went through speech, and we went through assembly. What are the limits that the courts have slowly but surely added over time on the Second Amendment? Because if you look here, there really hasn't been abundance of case law related to this issue. The court traditionally avoid Second Amendment cases for kind of what we talked about in the federal courts unit. The courts tend to steer away from issues that they feel are so politically divisive that they risk jeopardizing the perceived nonpartisan nature of the court. And so the courts have, again, largely avoided them, issuing those writs of certiorari, but that doesn't mean that they've refused to take any. In fact, there has been some evidence recently in the last 15 to 20 years that the courts are becoming more amenable to these cases. We saw first in DC v. Heller, where the background of this case was the District of Columbia, Washington, D.C., had passed a law that within the city limits, handguns were illegal. This was in response to just sky-high murder rates in the district back in the 90s. And so DC City Council passed a thing saying basically handguns, which are predominantly being used for crime because they're easily concealed, are no longer allowed in city limits. This was obviously challenged, as the DC City Council knew it would be. And it went all the way to the Supreme Court, where the court ruled that the federal government cannot restrict access to handguns. Now, this would seem to be an incorporation case, right? That it has incorporated the Second Amendment at the state level all across the nation. But if you think about it here, what is it about DC that may prevent this from being an incorporation case? Go ahead and pause and give a little think time. If you thought about it for a second and thought, wait a second, DC isn't a state, DC is managed as a District of Columbia by the federal government, therefore it's pretty clear that the federal government can't restrict access to handguns, but it did not establish a precedent for the states. That came in the case of McDonald v. Chicago, which is a must-know case. In McDonald v. Chicago, the city of Chicago basically did similar. They restricted access to handguns in response to sky-high murder rates on the south side of Chicago, and it was challenged. And basically, as we've seen in many other instances, the court used the 14th Amendment, remember the Equal Protection Clause, which is everyone, no matter where you live in the nation, is equally protected by the Constitution under the law. People in Illinois don't have less constitutional rights than people in Nevada. And so the court used the Equal Protection Clause of the 14th Amendment to basically say that, if people in Nevada and people in Montana and people in Washington can buy handguns, then just because you happen to live at an address in the city of Chicago doesn't mean you don't have access to the same Second Amendment rights. And so McDonald v. Chicago overturned Chicago's handgun ban and really incorporated the Second Amendment at the state level. Now, even as the Second Amendment is incorporated at the state level now as a result of McDonald v. Chicago, that does not mean that the right to bear arms is unlimited. And I think this oftentimes gets overblown by Second Amendment enthusiasts who, like to presuppose that just because there is a constitutional right to bear arms, that means all arms. But the reality is that has not been and continues to not be the case. It has long been established and upheld by courts that states are allowed to restrict concealed weapons, either to prevent them or require a permit to carry a concealed weapon. In order to carry a concealed weapon in permit states, you have to basically submit extra burden of proof that you are of sound state of mind and not, possessing of a criminal history. These extra restrictions have been upheld by the courts as still not contrary to what was established in the Second Amendment. So they can restrict concealed weapons. It's also been upheld by courts that states are allowed to restrict access to firearms to convicted felons or those with diagnosed mental illnesses. And so, this argument put forth by the Second Amendment, interest group and Second Amendment enthusiasts that the right to bear arms is unlimited is clearly not supported by case law or history, as the right to bear arms has checked and kind of limited in a variety of different ways. In fact, one of the most famous conservatives of all time, Ronald Reagan, right, the poster child for conservatism and laissez-faire and neoliberalism of the 1980s, free trade, conservative, Ronald Reagan was the grandfather, or was the kind of person leading the charge to ban automatic weapons, right, machine guns. Right? You can't have a machine gun. Now, the difference, for those of you who don't know weapons, between an automatic weapon and a semi-automatic weapon is, in an automatic weapon, you push down the trigger and you can hold it and you can spray 30 bullets in 3 seconds without needing to actually press the trigger 30 times. A semi-automatic weapon, you have to actually manually fire that round by the squeezing of a trigger. And, depending on how fast your trigger finger is going to limit how much damage one can do. Automatic weapons were banned, and nobody really talks about that everyone should be able to buy a Browning military-grade machine gun, right? That ship has sailed. Everyone seems to be okay with it. There's limits on where you can carry guns, right? You're not allowed to carry guns in schools in many states. You can restrict access to specifically dangerous and unusual weapons. I said rocket launchers or automatic weapons. And so the courts have upheld, with that little knock at the door and the dog's going nuts. What I'm getting at here is, while the right to bear arms is enshrined in the Second Amendment, there has been obviously numerous challenges by the court that allows states the ability to limit in certain ways. I think this is important because what we see right now in the debate nationally is oftentimes this slippery slope argument that if you, restrict access to AR-15 assault weapons, right, that is going to be basically the first step to them coming after your shotguns and your handguns. But I think, honestly, for those who watch federal law and these things go through, that stuff's established. McDonald v. Chicago basically has established that handguns and, guns for reasonable defensive purposes, like shotguns, are enshrined in the Constitution. They're not going anywhere. The question now then becomes, what about the military-grade, semi-automatic assault weapons that are being used in these mass killings like Las Vegas or Newtown or whatever? Are those is there the right to purchase those constitutionally enshrined? And I think that remains the open debate. The court is fairly conservative right now, and so is probably unlikely to kind of restrict or overturn some of these current gun realities. But again, the debate unfolds over time organically because that's how the law works. The Second Amendment has been incorporated as of McDonald v. Chicago, and much of it is, that ship has sailed, the cat's out of the bag, you're not getting it back in, but the limits are also there. Moving on, I want to look at this: what rights do defendants have according to the Bill of Rights? If you remember on that Do Now a couple days ago, where I asked you which Bill of Rights numbers have experienced the most amount of challenges, we said the first or the sixth. And the sixth was a trial amendment, right? The right to a speedy and a fair trial with an impartial jury. This is enshrined in the Constitution as a result of things experienced under the reign of King George. So let's take a look specifically at the trial amendments, which are the 5th, the 6th, the 7th, the 8th. And honestly, if you look at the Bill of Rights, outside of the most famous first and the second, and then, I plead the fifth, and then arguably the 10th, which is the Federalism Amendment, right? All powers not expressly granted to the federal government nor denied the states are exclusively the domains of the states. Remember, that's the 10th Amendment. Outside of those most famous ones, the majority of the the amendments in the Bill of Rights are dominated by amendments or civil liberties provided to people accused of crimes. Obviously, like I said, the context is the abuses of the British. And if you were to actually number them, it's the 4th, the 5th, the 6th, the 7th, and the 8th. All deal with trials and courts. Some are more well known than others, but nearly all of them by now have been incorporated at the state level. We're going to look at some of them, the big cases, because some of them are must-know cases, right? Like the Miranda v. Arizona, where you have the right to remain silent. Anything you say can and will be used against you in a court of law. That's a must-know case. We'll talk more about that. But let's talk about the 4th, because the 4th is a pretty unsexy Bill of Rights amendment, but it is critically important when we talk about protections granted to citizens from their own government, which is the 4th Amendment protects you from unreasonable search and seizure. Now, the law really has blossomed in this area because what is meant by search and seizure is not just, a traffic stop and can the cop who pulls you over for a broken taillight, can they search your trunk? Or, can you just stop somebody on the sidewalk and frisk them, like stop and frisk laws in New York City famously years ago? It's not just that, right? The 4th, unreasonable search and seizure also, has been understood to mean, when the police bring you in for questioning, right? That's a search. It's a search of the information that you have. It's kind of a search of your brain if you want to think abstractly. That essentially, when we look at it piece by piece, what has been seen by the courts to be unreasonable search and seizure, let's start with the most obvious. Police must possess probable cause before they can search you or arrest you. The police, when searching for a mass murderer, cannot just knock on every person's door in a neighborhood and say, we demand that you submit a polygraph test. Or knock on your door and say, sir, we're going to search your house right now, right? That's not okay. In order to get a warrant to search a person's car, to search their house, or to arrest them, you have to demonstrate that you have probable cause, meaning that you have reason to suspect that this person is a perpetrator of a crime that you are looking for. Right. And so that has been a pretty high hurdle for police, right? That, depending on the district attorney or the judge issuing warrants, generally a judge is going to say, well, you need to make your case to me. Why do you think this person is worthy of a search? And if the police can't put forth a reason, then the warrant is not going to be issued. And if the police stop you and, come up with this like, well, I smelled alcohol in your breath and it turns out that you weren't drinking, and in the search they find something illegal in your trunk, that's most of the time going to be tossed out, because that seems like most judges are going to say there was no probable cause, that was like fictionalized. Warrants, as you've seen in many cop shows, are the official demonstration of probable cause. You go to a judge, you say, this is what I got on this person. This is what I think I need to search their basement. And the judge will issue the warrant. But warrants must specify a specific item or items being sought after and a limited area. So you can say, I want to search this person's storage locker. I want to search, the basement of their house. I want to search their whole house, right? I want to search their parents' house in addition to their basement. But you have to specify a limited area. You can't say, I want to search every single place this person has been in the last 3 months, including their job and their girlfriend's house and their friend's house. A judge will never issue that warrant. Searches can be warrantless with certain conditions being met. And this is where you get those dirty cop shows of people, basically saying, well, I heard somebody scream inside, or, I found the door propped open. And it's like, well, that was not true. That's just, he's saying that to justify a warrantless search. But searches can be warrantless according to the courts if they meet a set of parameters that I will reveal in part 2.